Steve Vladeck, Professor of Law and Associate Dean for Scholarship at American University, Washington College of Law. So I think we actually do now have a pretty good idea of the government's legal defense of the various programs that we now know about thanks to Edward Snowden and those disclosures. And the defense really rests on two legs. The first leg is that Congress, in all relevant respects, has authorized, for example, the bulk collection of phone records, the interception of content data that is targeted at US persons, non-US persons overseas, and that Congress actually indeed did know what it was doing when it authorized them, has signed off on them, and so on, so that there's at least statutory grounds for the programs. The second, I think, is actually the more interesting question going forward, which is that these programs don't violate the Fourth Amendment. And that argument really is predicated on a 35, 36-year-old view of the Fourth Amendment and on something called the third-party doctrine, the notion that when we give our records to some third party, when we communicate with a third party, we are surrendering our expectation of privacy because we have no control over what the third party does with that information, just like this interview. I have no control over what you guys are going to do with this video. And the problem with that view is that even this Supreme Court has already suggested that it might be time to revisit that idea, that in this digital age, when we are communicating so much information constantly to so many people, that it actually might be worth revisiting what it means to have an expectation of privacy in digital content, in metadata, in all kinds of information we're sharing with banks, with our credit card companies, with our friends, with our Facebook friends. And we saw this 2 years ago when the Supreme Court decided the Jones case, where the justices all agreed that it was a search for the government to physically install a GPS tracker on this criminal suspect's car. But 5 of the justices also suggested that the pervasiveness of the surveillance, that the amount of information the government was collecting on this one suspect was enough even without the physical trespass. And in the process, they suggested it was time for us to revisit this 36-year-old precedent and to rethink the third-party doctrine. And I think that's the big question going forward. Whether these programs are going to survive on legal grounds is going to depend a lot on whether the Supreme Court is up for modernizing the Fourth Amendment and for revisiting what it means to be private at a time and age when we live so much of our lives in public. Well, and I think part of the problem is not just the I have nothing to hide mentality. I think it's also the fact that in many of these cases, the data is making our lives easier. So if you use mapping applications when you're driving, if you use applications to order food to come to your house, the fact that these applications are keeping tabs on you, are knowing where you are, what you've ordered in the past, where you go, at what times you do it, those are actually making our lives more convenient. And so I think part of the tension we're seeing is between this reality that data actually is in many ways efficient and makes our lives more efficient, with the concern of what could happen if that data fell into the wrong hands and were used for the wrong reasons. And so I think we have to be very careful to separate out data that we are providing knowingly and voluntarily to third parties to streamline our lives, and then the government's separate ability that we weren't previously privy to really aggregate across those data streams and to build a fairly comprehensive picture of what we're doing on a daily basis. And I think the problem is that Americans are focused on the first part of that question, where there's actual general agreement that this is not a terrible thing, and we haven't paid nearly enough attention to the second part, which is how this data could be used, could be co-opted, could be brought together to really distort fairly fundamental privacy ideals. Well, and in reality, I mean, if we are concerned about private data collection, and there are at least some contexts where we probably should be, the remedy there is Congress. I mean, the remedy there is legislation that I think better protects privacy, at least maybe not by preventing these companies from collecting the information, but how they use it. Can they use it for secondary purposes, for example? Can they hold the data forever? The problem in the government context is that we're not just talking about companies trying to figure out what to sell you or how to market to you. We're talking about your lives and your well-being. We're talking about, can the government build a criminal case against you because they can prove that on day 1 you were in location A? Right? Can the government actually figure out that you've been cheating on your tax returns because they actually are privy to much more financial information than they would have been 10 or 20 years ago? And the thing is, we may not actually believe that those are bad things. Right? We may say, well, if you actually are committing a crime, the government should know. If you actually are cheating on your taxes, the government should know. But the amount of information the government would have to collect on innocent Americans in their everyday lives in order to have that capability is where I think we really need to be concerned, and where I think there has been insufficient attention thus far. So I think the most important thing to understand about the FISA Court is that what it's doing today is really radically different from what it was set up to do. So back in 1978, when Congress created the FISA Court, all that the court was doing was a classical warrant application. The government would come to the court, they would say, we believe John Q. Citizen is an agent of a foreign power, and the government would have to show probable cause to the court to determine then whether or not John Q. Citizen really was an agent of a foreign power. And although it was done in secret, it's actually not that unusual, because in the ordinary law enforcement context, the same thing happens. The government goes to a district judge, a local judge, et cetera, and behind closed doors, without the benefit of adversary counsel, without notice to the defendant, the government says we have probable cause to believe that John Q. Citizen committed a crime. So when FISA was enacted, when the FISA Court was created, the break from the norm, the break from the status quo was not that radical. What changed after 9/11 is Congress, for the first time, gave the FISA Court basically a form of administrative oversight. Instead of just signing off on individual warrant applications, now the FISA Court was asked to sign off on programmatic surveillance requests. So, for example, the phone records program. The government would not go to the FISA Court and say, John Citizen is a suspect, we need his phone records. The government would go to the FISA Court and say, in order for us to find all of the suspects out there, we need all of Verizon's records. And that's a very different kind of judicial review, and it's a very different kind of oversight. And it's one that I think we haven't fully appreciated as a seismic shift in the role of the FISA Court. So I guess my own view is I think the FISA Court is perfectly well set up to do what it was originally designed to do individualized warrant applications based upon probable cause showings by the government. What the FISA Court is less well set up to do is this structural surveillance, is this effective oversight of whether the government is conducting these programmatic surveillance authorities, these bulk collection authorities, in ways that are consistent with statutory and constitutional values. And I guess one of the best ways to see this problem is in that context, if this were to happen in a normal court, you would always have adversarial process. You'd always have someone on the other side arguing against the government. Congress provided for that when it created these new authorities. Congress says there could be someone who shows up and argues against the government, but it's not the target of these surveillance. It's the recipient of the order. So when the FISA Court issues an order to Verizon, say, for all of our phone records, Verizon has the right to show up and contest it. But Verizon's not really there to look out for us. Verizon's not really there to look out for its customers' rights. And indeed, we learned last summer, Verizon had never done it, right? No recipient of one of these orders had ever stood up to the FISA Court. So, I think the real problem with the FISA Court is not that it operates in secret, and it's not that it is, I think, in this classified facility here in Washington. I think that's necessary to the beast. The real problem is that when it's doing non-individualized surveillance, when it's approving mass and bulk collection of data, of content, of business records, and so on, there's no one on the other side arguing against the government. And that's why you've seen so much push in some of the reform proposals to have this idea of a special advocate, of some lawyer, a security-cleared lawyer, who would be there to argue against the government, who'd be there to say to the FISA judge, well, yes, that's the government's position, but have you considered this case, or this statute, or this new development? That's what's missing from this process. I think it's hard to say whether things have gotten out of control because I think we still don't know what we don't know. It's certainly the case that we've had a radical revisiting of fairly fundamental assumptions about the relationship, for example, between the private sector and the government, between Americans and the government, between our privacy and national security. I do think actually the private sector plays a critical role in this conversation because they don't just have to answer to the government, they have to answer to their stockholders, and increasingly they have to answer to foreign governments. These companies are doing business overseas, they're doing business in Europe in companies with far more aggressive and robust privacy protections. And so I think a larger part of this conversation is not, is the government being too aggressive, but rather is the government being too, for lack of a better word, exceptional. Is the government not thinking about the consequences for the ability of American businesses to really work effectively overseas and to attract foreign businesses to come do work here in the United States if it's subjecting these companies to far more aggressive intrusions than any other country in the world is subjecting them to. Now, we may think as a matter of policy that those more aggressive intrusions are necessary. I think it's worth keeping in mind that at the end of the day, this comes at the cost not just of our privacy and our civil liberties, but also potentially it comes at a cost to the bottom line of these corporations. And I think that's part of why you're starting to hear them push back a lot louder. Sure. So I'm the co-editor-in-chief of a blog called the Just Security blog. It's justsecurity.org. And our blog is basically just an effort to bring together lots of different viewpoints on these and other topics of interest of import on questions of U.S. national security law and policy going forward. Because I think one of the things we've learned over the last year is that Americans are going to have different answers to these very difficult questions, and that's healthy, that's good, that's exactly the way that democracy should work. The key is information, the key is educating the public, and that's an obligation that we all have, the government first and foremost, but also those of us who work on these issues from an academic or a policy perspective, that it's most important first and foremost to ensure that the conversation is happening at the highest level of debate. That's right. No, I mean, our hope with our blog, and indeed I think most of our hope with all of our writing, is that we are making these issues accessible to individual Americans, to readers all over the world, because our goal is not to convince anyone that we're right. Indeed, we don't all agree on anything. Rather, I think the goal is to ensure that this conversation is happening on terms that actually make a difference, as opposed to these sometimes hysterical, politicized terms that you see in conversations in the public about national security. I mean, at the end of the day, we all actually agree on so much. We all agree that the government has a critical interest in protecting the country. We all agree that that interest should, at least be somehow calibrated to respect privacy and civil liberties. We all agree that it's just a question of line drawing. But understanding the tensions, understanding what's pulling in one direction, what's pushing in the other, really demands better civic discourse and more educated civic discourse. And I think that's the first and foremost goal of these kinds of enterprises like our blog. So I think that the key to understanding the European decision, the key to understanding there was a Second Circuit decision recently about when the government has to delete information it's obtained through a warrant. The key is, I think, to understand that there are two different questions when we're talking about the government's collection of information. The first is the collection question. Under what circumstances and pursuant to which conditions can the government initially obtain this information? The second is what happens after that? Once the government has this information, can it hold on to it forever? Is there a point where they have to destroy it, where they have to get rid of it? Because both of those implicate our privacy. And we may all agree that the government should have much broader collection authorities with much harsher use restrictions, that they can't use driver's license data for tax records, right? They can't use blood collected as part of a blood drive for criminal evidence in a criminal case. I mean, those are the questions we have to think about. But how this data is used, how it's stored, when it has to be deleted, whether we have a right to be forgotten, I think that's the second part of this debate. And it's a debate where, again, we're all going to disagree on what the right answer is. But we should all at least agree that it's a debate worth having with as much information about what the competing options are as possible. Should the government hold our phone records forever? Should they hold them for 1 year? Right? Should they hold them for 2 days? There's got to be a line somewhere. And that line's going to be informed not just by the government's needs and by our own sense of our privacy and civil liberties, but also by the compromise that is inevitable when you have meaningful democratic discourse on questions of national security. That's what had been missing until last summer. And that's what I think we're now finally beginning to engage with after and in light of the Snowden disclosures.